number 9 of the House of Commons Standing Committee on Citizenship and Immigration. We have 2 panels of witnesses today, and for the last 15 minutes of our second hour, I'm going to go in camera so that we can discuss committee business. So in terms of just a few general comments off the top, today's meeting is taking place in hybrid format, so we do have someone joining us by video conference. And so I'm going to make a few comments. For those that are participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. For those that are participating in video conference or Zoom, at the bottom of your screen, you could select the appropriate channel for interpretation. You could choose either Floor, English, or French. And of course, for those that are in the room, and these remarks are specific to our witnesses, you can use the earpiece if you need to listen to either French or English. I have 2 cards, which I will whip out of my knapsack while one of you guys starts speaking. If I hold up a yellow card, it means you have 1 minute left. Red means your time is up, and your microphone goes off. Always kindly wait until I recognize you by name before speaking. And please, 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 and please do not speak over each other. It will be very hard for our translators to translate, and it makes their job very difficult. Of course, please ensure that all comments are addressed through the chair. And members, as you know, raise your hand if you wish to speak. The clerk and I will manage the speaking order as best as we can. And I thank you very much in advance for your cooperation. And I want to say a warm welcome to Mr. Fergus, who is here in place of Ms. Sodhi. You are warmly welcome, sir. Pursuant to Standing Order 1082 and the motion adopted by the committee on September 16, 2025, the committee is resuming its study on Canada's immigration system. It is with great pleasure that I announce our witnesses for the first hour of today's meeting. As an individual, we have Mario Bellissimo, lawyer, certified specialist, Bellissimo Law Group Professional Corporation. I don't think that you are, I think you're someone that's well known to this committee, sir. And so welcome to you. Hong Kong Watch. From Hong Kong Watch, we have Eileen Caverly, co-founder and chair. Welcome. And Stats Canada, we have Laurent Martel, director for the Centre for Demography. Welcome. And then via video conference, we have Ron Gravel, Director General, and nice to welcome you as well. So each of you, so each as Mario, Hong Kong Watch, and Stats Canada will have up to 5 minutes each for opening remarks, after which we will proceed with rounds of questions. So I'm going to ask Mr. Bellissimo to start us off for 5 minutes.
Thank you, Madam Chair, Vice Chairs, honourable members. It's a pleasure to appear again today before the committee. So Canada's immigration system stands at an inflection point. It faces many challenges. Those specific to my comments today include over 2 million applications pending and processing times extending into decades. The absence of timely communication, no redress for minor issues, and years of digital stampedes have created cascading effects, duplication, declining transparency, and mounting pressure on tribunals, courts, and Parliament itself. These problems point to a widening gap between policy ambition and administrative capacity and delivery. IRCC has made real progress through digital transformation, client service reforms that reflect genuine commitment. The issue, however, is not commitment or dedication, but architecture and delivery. So this study arrives at a pivotal moment. Our brief that will hopefully be before the members once translated draws upon the CBA's 2025 Law, Technology and Accountability Report, Reimagining Canadian Immigration in the 21st Century. It has 100 recommendations to strengthen governance, fairness, and transparency, a must-read for those committed to creating a new, co-creating a new way forward. And I encourage the committee to hear directly from the CBA. So our brief builds on that foundation as well as others, COSTI, CD House, TMU, Broadbent, and we put forward 10 fiscally realistic recommendations to make immigration delivery more transparent, predictable, and accountable. So at the heart of our proposals are two imperatives often seen as competing, but in fact complementary: facilitation and enforcement. Facilitation will demand a new ethos of communication, transparency, and timely delivery at IRCC. Enforcement must be firm but proportionate, focused on integrity and not control. Bill C-212, the Strong Borders Act, illustrates the risk of overcorrection. It consolidates broad executive powers without adequate parliamentary oversight and clear procedural safeguards. It does risk deepening the very stability it seeks to correct, with serious consequences, including constitutional vulnerabilities. We call for more parliamentary oversight, widespread consultation and collaboration, a statutory immigration ombudsperson, so applicants, for example, can seek redress without turning to the federal court simply to learn at what stage their application is at. We also urge binding service standards through the Services Fee Act, a universal expression of interest model to transparently align application intake with delivery, ending the cycle of runaway inventories, security check delays, and siloed decision-making. For example, families in need of care for elderly loved ones should not wait years for the support to live with dignity. We cannot allow false narratives around immigration to take hold. We must better communicate the essential role that immigrants play at every level of our society to push back against division, hate, and otherness. Parliament should link levels to indicators in housing, healthcare, and labor while ensuring the vitality of Francophone communities across Canada, preserving both growth and cohesion. Also, we make suggestions towards an enhanced refugee system that will protect humanitarian commitments while reinforcing timely border integrity. And as technology reshapes immigration decision-making, we need stronger legislative AI and automation oversight and digital equity, as well as statutory recognition of counsel to safeguard fairness and due process in the immigration world is essential. These measures reflect global best practices and would free resources through smarter upstream reform. They do not require major new spending, just enhanced coordination, accountability, and openness across departments, across ministries, tribunals, and courts. Before closing, I want to acknowledge the dedication of many government officials, settlement agencies, and legal professionals who continue to deliver under immense pressure. Their commitment is not in question, but they need a stronger framework, one consequential to all current and future Canadians. Thank you. I look forward to your questions.
Thank you so much, Mr. Bellissimo. Excellent time.
Well, thank you very much for appearing at committee today. You put a number of things on the table, but I want to ask you about the digital turn that we're seeing, and there's many democracies taking that up in a variety of ways, trying to understand how the digital transformation, the revolution, in fact, that we're seeing, how that can make government services more efficient. Do you have thoughts or a recommendation to this committee specifically on that, how that could help in more efficient processing time, for example, at IRCC?
Yeah, thank you for the question. I think we can look at the European Union AI Act, as well as Italy just passed a comprehensive package. My belief is that with legislative guardrails as to explainability, notice when it's used, plain language, the opportunities are immense for wonderful leveraging of technology. Much of what we're talking about today can be heavily alleviated with proper tracking when the technology allows that. But if we do it without those guardrails, you now have things like algorithmic impact assessments and privacy impact assessments, which are wonderful. But we need to get it to a mass universal level where all people can understand how it is benefiting, as opposed to creating a narrative of one that it is to be feared, when it's really the opposite if deployed ethically and innovatively.
Sir, I only have 30 seconds. I wish I had about 3 hours to talk to you about this. We'll have to follow up. But you would say then that Europe is ahead on this, and we can look to their models there. You mentioned artificial intelligence and what you seem to believe is a balance, an appropriate balance between AI, but also ensuring that privacy is maintained, things are done efficiently and effectively, but ultimately in a way that's congruent with democratic principles.
Yes, I think
quick
we have
response,
some good,
please.
Yeah, I think we have some good things in Canada, like the some of the soft law and directives, but I think we need to codify those so they have teeth.
Yep. We have 7 minutes left, so I'm going to give 3.5 minutes to the Conservatives and 3.5 minutes to the Liberals. So, Mr. Redekop, you're up for 3.5 minutes.
Thank you, Madam Chair, and thank you to the witnesses for being here. Mr. Bellissimo, you spoke in your opening remarks about C12 and constitutional vulnerability. Could you maybe expand what you were referring to there?
So I think that's in respect to any time we set timelines as it relates to refugee claimants, 14 days, 1 year, you risk losing an individualization of the process, and the fact that they may not then have a hearing before removal, even though they might go through the pre-removal risk assessment process, has constitutional vulnerability, as does some of the potential data sharing that, albeit some of it has now been tabled in C2, but in C12, that kind of data sharing does get into some privacy concerns and risks pushing us back.
So in your opinion, that C12 is at risk of being constitutionally challenged?
Yes, I believe it is, as it currently reads.
Okay, thank you. You were here, I think, last Parliament a number of years ago, and you talked, I think what I recall the discussion was about approving technology and things like that were needed. And since then, we've had this massive failure on the part of the government with asylum claims and a lack of managing the system, which has led to people being almost compelled to do asylum. And I guess my question for you is, do you see a strain being put on the system partly because of that? And are there some changes that you think should be made in terms of technology?
Yeah, I think, as I referenced in my previous response, I think we need to leverage the technology to control intake versus output. We can have wonderful policy ambition, but if it's not tied to administrative capacity and basically an operational ethos of communication, transparency, and facilitation, we're going to continue to have runaway inventory, disappointed applicants, and basically damage to our global brand. So I think there's a wonderful opportunity leveraging that technology to bring that to ground and move forward in a much more coordinated way.
Part of the needs in a country like Canada is to be able to track people when they exit the country. Do you have any knowledge, or are you aware of any system that Canada uses to maybe track that, or do you think that Canada has the ability to do exit tracking?
Yeah,
1 minute left.
Yeah, they do have. They have an exit and entry system. They do track. CBSA is also developing a new tool called TCI, which is going to potentially use predictive analytics to determine could someone not comply when they enter Canada. These are potentially good initiatives, but we've learned from other countries like New Zealand when they've launched similar technology, it failed and it was found to not be predictive. It was found to be discriminatory. So
if I could just interrupt and you could
Sure.
finish off just kind of explaining the dangers of using AI and some of the, kind of where you're going here. Like, what are the dangers of implementing some of that technology?
The dangers are if the predictive analytics are used in a way that places people in digital prisons that are not unique to them, that are based on widespread characteristics. We move in areas where we've seen internationally, and in some cases in the criminal context here in Canada, where we can run afoul of privacy and proper identification and proper predictive work because the technology is not there yet. That's why we need those guardrails, legislative guardrails.
Thank you, Mr. Bellissimo. Thank you, Mr.